The third initiative came from the Law Commission of India. The 14th Law Commission submitted its report in 1958. It studied both Bombay Legal Aid Committee and West Bengal Legal Aid Committee recommendations and approved their recommendations, and said that the free legal aid to the poor persons and persons of limited means must be provided by the state, and it is a duty of the modern state, particularly because when it is a welfare state, it owes that duty to the citizens. And it insisted that the states must accept this obligation. And it also talks about the states must provide funds for the legal aid to the poor. And in addition to the state responsibility, again the Law Commission, expressing its solidarity with the earlier report, says that it is also a responsibility of the legal professionals to provide free legal aid. The legal profession, according to the committee, owes a moral as well as social obligation to the poor in providing free legal aid to the poor persons, at least to some extent. Then further, the commission report says that before they could implement these legal aid schemes, the state should implement such schemes identified by the earlier committees, make provisions for legal aid in a gradual stages. That means even if you are not in a position to implement the entire scheme at a time, gradually try to implement it. And the committee also requested the government to take measures to adopt legal aid as soon as possible. Further, it says that the bar associations also should take immediate measures to render the legal aid on a voluntary basis. And its another recommendation is to amend Civil Procedure Code. It specifically talks about Rule 1, Order 33 of the Civil Procedure Code, which talks about pauper suits. The commission suggests that it is better to define who is pauper, and also finds objectionable to use the word pauper, and it should be replaced by the expression of poor person or an assisted person. In 1952, the central government made several efforts to see that the legal aid is reaching to the poor. So in 1952, it recommended the state governments to make provisions for legal aid in criminal cases in respect of offences which are punishable with not less than 5 years rigorous imprisonment, and also an appeal from these arising out of these cases. That means the central government is requesting the states to provide legal aid to the poor if it is a criminal case where the offence is punishable with 5 years or above with a rigorous imprisonment. However, the same story repeats. The states express their inability due to financial constraints, hence it was not heeded. Again in January 1956, the government of India wrote to the states to increase the scope of legal assistance to the poor, and they said that they are seriously considering of inclusion of this provision in 5 years plan. And the central government urged the states to make a provision for legal aid in the state budgets. Again, the states responded saying that they don't have sufficient financial stability to provide a special budget or allocate a special budget to the legal aid, and therefore the appeal failed to evoke any good response from the states. However, some states did make some kind of a contribution. If you look at it, is just a token of amount was allotted to the legal aid. It is ranging from 1000 rupees to 2000 rupees in the annual budget. And even though the central government promised that they are considering to include legal aid in the 5 years plan, the legal aid was given very little importance in the 5 years plan. That means both the central government as well as the state government, whatever the reasons, whether it is financial reasons or other considerations, are not very serious about implementing the legal aid. In 1957, the Kerala government adopted Kerala legal aid to the scheduled caste and scheduled tribes and the poor rules. Under these rules, any person whose monthly income is below 100 rupees is entitled for the legal aid, and this legal aid includes the fees to the advocates, and the poor persons were entitled to the legal aid in all criminal cases before the high courts, sessions courts, as well as before the magistrates. Further, the rules also says that the scheduled caste and scheduled tribes were entitled for this kind of legal aid. In 1957, the Law Ministers Conference suggested that each state government should formulate a special scheme for the legal aid to the poor. And the most important thing under this conference is that the mandatory appointment of the committee at different levels to entertain applications from the poor. And it also insists that each state should forward the Central Ministry of Law regarding the schemes they have formulated in providing free legal aid.